this guy's garage. Like and subscribe.
Any other law in Canada? And I do want to give you the opportunity to speak to that, Professor West, because I'm curious you brought it up, but I'm not clear about where you were going with it.
Any other law of Canada means any other federal law, not literally any other law of Canada. This was decided by the Supreme Court in Roberts in 1989. And in that case, it was interpreting Section 101 of the Constitution, but it held that either it includes federal statute or federal common law. Typically, federal legislation says any law of Canada or of a province or any other law if it's used to denote wider application. And the reading of any other law of Canada makes more sense in this if you look at parts A and B of the definition as well. Part A would become redundant because it already says it has to be beyond the authority and capacity of a province, and Part B doesn't have anything to do with provincial jurisdiction. So realistically, once the executive has decided that the criteria in the chapeau and A or B are met, all they need to look to then is whether or not there's other federal statutes for them before they invoke the Emergencies Act.
I have to say I regret not inviting you to this committee earlier because that is a significant interpretation that I don't think we had been made aware of. So just so that we're clear and for the purpose of the record, you're suggesting in that analysis, in that legal opinion, that regardless of the fact there was a breakdown municipally with the local police here, regardless of the fact that provincially they had tools both through the Ministry of Transport, maybe perhaps some other incentives for the truckers to leave in the occupation, that really doesn't matter. Even if those remedies were available but not used, as you understand the Act, it is only federal, the federal laws or regulations that have been exhausted.
That first part goes to, if you're invoking under Part A, that goes to authority and capacity of the province, right? So you should be looking to see whether or not there are other authorities for the province to remedy the situation. Once you've decided that the province or the municipality doesn't have those authorities and you've decided that the definition is met, the federal government only needs to look at its federal.
And I want to get very clear about that first point.
Yep.
And so even if they have the authority, is it your opinion that if they have the authority but don't use it, it's the same thing? Like, because this is for me the practical crunch of the matter. Having the law and then having an effective failure of policing, I don't think was contemplated by Perrin and Beattie when this was correct. Would you agree with that assessment?
I would agree that the Emergencies Act contemplates everyone doing their jobs.
Right.
So it does, however, say authority or capacity. So if for some reason they don't have the capacity to fulfill their duties or use their authorities, that's a separate question because it does say authority or capacity.
Sure.
It does not need to be both.
Got it. Thank you very much for that. Acknowledge that your legal opinion is only formed based on the information that's been made publicly available and suggested that further scrutiny of knowing what the government knew and how they reacted to it would help in your legal analysis on whether or not the government made the right choice. Is that correct? Professor Roach, do you share that same opinion?
Yes. I mean, for example, it's been mentioned that the OPP had undercover operatives in the Ottawa protest. We don't know what they came up with. So, I really think that you can only fully investigate this if you do so in a manner that is in camera, subject to national security confidentiality. And I would add that I think, moving forward, you should consider that an inquiry would have powers to go behind solicitor-client privilege. And CIRA, for example, has those powers.
I would put to you that Parliament has those powers, that the conventions of cabinet confidence are only a convention and that ultimately we're the grand inquisitors of the nation. But the point that I wanted to make was more on the legal opinion, because this has been a challenge even for this committee, even given our parliamentary privileges, is getting access to the legal understandings in order for our own process to take due course and to be able to provide analysis. So I'll put the question to you and ask you if you could answer it briefly. Professor West, would you benefit from having the legal opinions, the internal legal opinions of the government made public for scrutiny and for the ability for subject matter experts like yourself and the public to have the ability to ultimately scrutinize and yes, and Professor Roach, would you agree that a legal opinion would be valuable in terms of looking forward on this topic, regardless of what side the issues are on?
Absolutely.
And it's important for me at least, to get very crystal clear about finding recommendations coming out of here, and having both of you here as subject matter experts is a very valuable source of that primary information that ultimately our committee will deliberate on. So just to be clear, do you believe that the Emergency Act in its current context adequately serves its intended purpose? Professor West? Professor Roach?
No, I don't. I would decouple the definition of emergency from threats to the security of Canada. I think it's kind of apples and oranges because I
want to get into specificity, Professor. I appreciate, but I don't have time on that regard. I want to know specifically what amendments would you propose to this committee?
I would propose of getting rid of 2C and going with a different definition of public order emergency, keeping Section 3. I would propose ensuring that the inquiry, and I know you believe it's within your powers, would have access to solicitor-client privilege.
For the record, that we are the Grand Inquest, not Inquisitors. I think that's Star Wars, but I digress. Professor West, in your opinion, what recommendation should we make?
So I would change the definition of public order emergency to remove emergencies caused by threat actors, which is essentially what it is now. I would still, if Parliament wanted to have the ability to respond to emergencies caused by terrorism, subversion, espionage, etc., I would think you would need to still keep that tied to 2C. But if you wanted a public order emergency to actually deal with public order emergencies and issues around potentially critical infrastructure, I would change the definition of a public order emergency to meet those requirements. Alternatively, you could have a public order bill, like the United Kingdom has introduced in its legislature, that provides specific powers and different offenses around critical infrastructure and threats to created by public order disturbances.
Thank you. And you may have heard me, even in this meeting and in other studies, talking about the practical failure of policing. It is not within our mandate. It doesn't within our scope here to be able to delve into that. But there hasn't been a Royal Commission on policing since 1962. Professor Roach, I know that you've written about unequal policing. I think it's fair to say, for many people on the outside looking in, there was certainly a double standard applied to this particular group. Do you agree with my assessment that we ought to embark on a Royal Commission on Policing to be able to unpack the responsibilities of police?
Absolutely, I would agree, and I would also look at reforming the Reading the Riot Act provision in the criminal code, which is, archaic, just to say it.
It's dying seconds here. Would you also support a Royal Commission on Policing to be able to look at the mandates and the...
Absolutely, and there's...
Sorry, my apologies. Professor Roach, I want to get Professor West on the record real quick.
Sorry.
Especially the structure of the RCMP needs to be reviewed.
Just the RCMP?
Well, in particular.
Would you agree with the statement that
yes, I do.
As it relates to the state of national emergency or the declaration, that it was all levels of policing that practically failed?
Oh, yeah.
In this instance?
The comment with respect to the RCMP wasn't tied directly to the Emergencies Act, just in general. I think that, yeah.
And so I can proceed with 4 minutes. 4 minutes, that's correct. And on the topic of accountability, you did mention in an article entitled The Dilemma of Mild Emergencies that are accepted as consistent with human rights. You stated that not having a requirement to examine the actions of the province in which the emergency occurred is an omission. Is it your recommendation to this committee that we contemplate providing a mechanism that would force the issue of provincial accountability and review?
Yes, I think as far as you can go is to provide for a formal request to the affected province to appoint a parallel inquiry. Obviously, that happened with mass casualty. That's not happened in this case.
Certainly an important consideration. And I know, obviously, Section 33 is invoked all the time in terms of provincial sovereignty, but in your remarks, Professor, you mentioned, if I recall, federal preemption. Can you expand on that and maybe perhaps provide some context to that statement?
Yeah, on matters of national security, there is a potential for federal preemption, also under peace order and good government, and the emergency parts of our federalism constitution. So just like the Security Offences Act can make both the RCMP and the Attorney General take the lead, I think that this may be an area where Parliament could legislate federal preemption. I can't guarantee that provinces would not challenge that as an infringement on their constitutional duty under 9214 for the administration of criminal justice, but I think that's a possibility.
In a practical sense, if that happened and that was legislated federally and the provinces refused to act or rejected this assertion, and of course in this very wild time of the Alberta First and Saskatchewan and Manitoba and all the others who want to break away from the country, if we were contemplating that, at least then the onus would be on them. Would you agree?
Yes. Yeah, and the Security Offences Act, which involves federal preemption, has been around since the CSIS Act, and I'm not aware of any challenge to it.
So on the topic of ideologically motivated violent extremists, do you share my alarm that there was reports of high-ranking military, including Joint Task Force 2, members of the Prime Minister's security detail at one point, former and current serving military people in the armed forces, as well as connections with the police? Were you concerned with the assessment that there was a infiltration of that element within the convoy?
I was concerned to an extent. I'm more concerned about the weapons and explosives found at Coots, but certainly that is part of an intelligence looking at the group. I also worry a little bit, though, that we have the police who seem to have more freedom to look at open source material and social media material than CSIS does, and to me, that again raises whether the police can actually distinguish or have the necessary intelligence expertise.
And on the previous comment, could you reflect on the infiltration of high-ranking armed services and police, people who had insight into logistics and tactical procedures that we've heard testimony had never been seen before?
Well, yes.
I'm sorry, Mr. Roach, the question is for Professor West.
Oh, sorry.
Starting point, I don't think there's anything wrong with retired service members and military members, police officers being part of a protest movement or helping lead that protest movement. It's the concerning part of it is if those members are also have violent extremism goals. That's what concerns me.
Like overthrowing the government?
Through violence, yes.
Thank you.